looked like she was trying to.
I lost my connection there for a second. Hold on one moment.
I will be patient.
Thank you, Alex.
Do we have technical difficulties placeholder music?
Do, 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 do. I don't know. I don't know what else it would be.
We don't allow for double jeopardy.
Lucas likes to whistle the little Spanish flea.
I don't know that one.
There we go.
Okay, should I count us in?
So you're saying we should ask nicely for... Yes, please.
Right? Going live in 5, 4, 3, 2, 1. We are live.
Good evening, everyone. Welcome to the February 27th, 2025 Rental Housing Committee regular meeting. The meeting is called to order at 7:02 p.m. All committee members are present with the exception of Member Rosas, who is absent. And we can start with the consent calendar. These items will be approved by one motion unless any member of the committee wishes to remove an item for discussion. The purpose of the consent calendar is for the committee to efficiently and quickly consider routine or administrative business items with one motion. Public comment will occur after the discussion. We invite you to submit a speaker card now if you would like to speak on this item during public comment. Would any member of the committee like to pull an item? Robert.
Yes, I just want to pull 3.
Microphone.
Sorry, I want to pull 3.3 for just some short comments.
3.3? Do we need to pull them? If you want to give comment...
I just want to give comments on 3.3.
Go for it.
Do it now?
Yes, please.
Okay. All right, thank you again for this activity report. Like I said, these are one of the things that I enjoy most about being on this committee, and quite honestly, in my interactions with the public, this is what I get the most questions on. What's the state of our rental housing market in Mountain View right now? So thank you for providing this information. So, I mean, I think that a lot of things in the report are positive. Rents on newly built units are down from $43.46 to $43.13, which is $33, and market rate rents on fully covered units are up, but only by 0.44%. Vacancy rate in newly built units, it's still kind of high at 13%, but I mean, there's a lot of new product coming onto the market, and so it takes time for that to adjust. So I understand why that's happening. The vacancy rate on the fully covered units went from 5.0 to 5.2%. That's still in the normal range, and that's very good because it means that people coming in here have a decent chance of getting a rent-controlled unit. It's not like they're all blocked up with people sitting on them, so I think that's positive. Tenant petitions continue to be the bulk of the inquiries at 35%, but inquiries are on a downward trend. I think we're still working through the process of letting people know about how this whole thing works and keeping them active in the process, so I think that's a good thing. There was nothing on Treo, no properties in redevelopment. That's because we're in a very slow market right now. And failure to pay rent notices is at the lowest point in 7 years. So that's a sharp decline and a wonderful thing. And there were no petitions from the MHRSO. There's only been 2 in the last 4 years, one on lawful rent, one on undue hardship. So I think things are working relatively well in our mobile homes. So those are my comments. Thank you.
Thank you. Would any other committee members like to pull or comment on an item? If not, we will proceed to public comment. So, in-person public comments will be called to speak first. Any member of the public wishing to provide a virtual comment on this item, please click the raise hand button in Zoom or press *9 on your phone. Staff will display a countdown timer on the screen. Just one moment so I can pull up the attendee panel. Seeing no comments, I'll bring the item back for committee action. A motion to approve the consent calendar should include reading the title of the agenda items 3.1, 3.2, and 3.3. All right, Member Keating?
Thank you. I move that we approve the consent calendar, including the minutes for the January 23, 2025 RHC meeting, the community CSFRA and mobile home rent stabilization ordinance financial expenditures for fiscal year 2024 to 2025 through December 31, 2024, and the rent stabilization division fiscal year 2024-25 activity report through December 2024.
All right. Motion made by Member Keating, second by Member Cox. All right. Motion passes unanimously to approve the consent calendar. So we will now open the meeting for oral communication from the public. This portion of the meeting is reserved for persons wishing to address the committee on any matter not on the agenda. Speakers are allowed to speak on any topic for up to 3 minutes during this section. State law prohibits the committee from acting on non-agenda items. Would any member of the public like to provide comment on a non-agenda item? If you would like to speak on this item in person, please submit a speaker card to the city staff now. In-person public comments will be called to speak first. Any member of the public wishing to provide a virtual comment on this item, please click the raise hand button in Zoom or press *9 on your phone. All right. Seeing no comments, we can get started with the appeal hearings. All right. The Rental Housing Committee, in hearing the appeal, is acting in a quasi-judicial fashion and will conduct the hearing in accordance with those standards. Staff will detail the appeal hearing process in their presentation. Before we get started, RHC members are required to disclose any communications they have had with any of the parties to the petition or the parties' representatives and the substance of those communications since the date the petition was filed. The decision of the RHC is to be based on the record presented to the hearing officer. Information disclosed to an RHC member that is not part of the record is not to be considered in the hearing. Do any RHC members have ex parte communications that need to be disclosed? All right. We will now proceed with public comment for both agenda items 5.1 and 5.2. Are there members of the public who are not parties to the petition who would like to speak? In-person public comments will be called to speak first. Any member of the public wishing to provide virtual comment on this item, please click the raise hand button in Zoom or press *9 on your phone. Okay. Seeing no public comments, we can move to agenda item 5.1, appeal hearing of hearing officer decision regarding petitions number C23240081 and C23240082. We will now proceed with the hearing.
Yes, good evening. First, I'm just going to go over the general information about appeals hearing, and then we'll get into the first appeal hearing. So the purpose for tonight is to consider you have 2 tentative appeal decisions, and you're being asked to either accept those appeal decisions or modify them with instructions to staff citing the appropriate evidence in the record. Next slide. So we're going to just go over the process very quickly. You've seen this before quite a bit recently, the decision process, the schedule, and then we'll go through a summary of the case. Next slide. So the RHC has 2 options when they're hearing and deciding an appeal. They can go with a closed record, meaning You are deciding the case based on the facts in the decision written by the hearing officer. You're not looking at new evidence. There is an option to do an open record, meaning a de novo hearing, where you would essentially hear new evidence and reconduct the hearing. We do not recommend that for either of these appeals. So the other option, and you will see in both of these decisions, we are recommending remand on particular issues, is to remand so that the hearing officer can re-examine some of the facts. Next slide. So the RHC, in considering these decisions, is supposed to exercise its independent judgment with regard to questions of law, such as the interpretation of the CSFRA. That's what is called de novo review with regard to the law. For questions of fact, you need to determine whether or not each of the appealed elements of the hearing officer decision is supported by substantial evidence. We're not reweighing the evidence or relitigating the issue. The appeal is based on the record as submitted to the hearing officer, so we're not considering new evidence. And it doesn't mean that you would have come to the same conclusion as the hearing officer. Next slide. So once again, we are not favoring a de novo evidentiary hearing for either of these appeals. That would be a formal hearing. It would require a significant amount of time. And we think, except for the issues that we are proposing remand, that there's sufficient evidence in the record for both of these decisions. Next slide. So just as a reminder, the petition itself defines the scope for the hearing officer's decision, and then the appeal defines the scope for the appeal decision. So the appeal may be more limited than the issues that were decided at the hearing. Next slide. And this is just a visual to show you the process, that we can actually have multiple appeals, particularly in this instance where we have remands. This could come back to you after the remands. Next slide. And this is the process that's in your regulations for the appeal hearing. We are in the midst of the staff presentation for each of the appeals. There would then be an opportunity for the appellant to make a presentation. They will have 10 minutes. The respondent will then have an opportunity to make a presentation for 10 minutes. Then each party will have an opportunity for rebuttal for 5 minutes. And then the RHC can ask questions of staff and questions of the appellant and questions of the respondent, and then you will deliberate and make a decision. Next slide. Okay, so your first appeal hearing tonight relates to petitions numbers C23240081 and 0082. Next slide. This is a petition for a downward adjustment of rent. The petition sought a downward adjustment on 3 grounds: habitability conditions, reduction in housing services, and unlawful rent. Next slide. The downward adjustment for habitability issues was based on the respondent's failure to maintain safe and secure common areas and failure to safeguard the petitioner's privacy and safety by entering into the petitioner's unit without permission and hacking the petitioner's computer network. The decrease in housing services claim was based on the respondent's failure to fix automatically closing and locking doors to common areas in the apartment building. And the unlawful rent claim was based on the respondent's failure to roll back petitioner's rent pursuant to the CSFRA. Next slide. So this is just a timeline of the process. I'm not going to go over it all, but if you want to see how the process proceeded, you have it before you. Next slide. So the hearing officer's decision concluded the following: that the petitioner had met his burden of proof, that the respondent had unlawfully increased petitioner's rent and, failed to roll back petitioner's rent pursuant to the CSFRA. The hearing officer ordered a rent refund in the amount of $13,152 as a result of the failure to roll back the rent and the unlawful rent increases. Next slide. The hearing officer also found that the petitioner had met his burden of proof, that the respondents failed to maintain the self-closing and self-locking mechanisms of the exterior doors to the apartment complex which represented a decrease in housing services. And based on that failure, the hearing officer ordered a rent refund of $6,100. Next slide. The hearing officer also found that the petitioner had met his burden of proof and that the petitioner had experienced a harm related to inaccurate electrical metering that resulted from the prior owner's renovations and ordered a rent refund of $5,200. Next slide. The hearing officer found that petitioner had not met his burden of proof with regard to the respondent or the prior owner invading petitioner's privacy by interfering with the computer network or entering petitioner's home. Next slide. So the appellant respondent raises 3 issues on appeal. First, that the hearing officer erred in finding a reduction in housing services as a result of the self-closing or the lack of self-closing and self-locking exterior doors. The hearing officer erred in finding that petitioner had been overcharged on utilities due to the electrical meter issue, and is also claiming that the hearing officer's entire decision should be reversed because the the respondent was improperly served. Next slide. So the tentative appeal decision is recommending that the hearing officer's decision be affirmed in part and remanded in part. Based on the evidence in the record, the hearing officer did not err in finding a reduction in housing services related to self-closing and self-locking doors. The petitioner testified that the doors previously had a self-closing, self-locking mechanism. The appellant landlord asserts they never had it, but actually did not offer any evidence to that effect on the record and in the hearing. And it would just be noted that the property manager, who had been the property manager for the prior owner, was in attendance in the hearing and could have testified to that manner. So the hearing officer did properly weigh petitioner's testimony against the respondent's lack of testimony and evidence and determined that there was a reduction in housing services. Next slide. The hearing officer's decision regarding the inaccurate electrical meter should be remanded for further consideration. The hearing officer awarded petitioner $200 a month to compensate for the inaccurate electrical metering, but there actually was not sufficient evidence presented to determine whether the petitioner had been paying utilities in addition to other units, so for the petitioner's unit and for other units, or potentially paying utilities for a unit that was not the petitioner's unit, but not necessarily paying utilities for his own unit. Additionally, there were no electric bills presented, so there is no information in the record about the amount that the petitioner might have overpaid if the petitioner was paying either somebody else's utility bill or paying multiple units' utility bills. So the tentative appeal decision is recommending a remand to determine the exact nature of what the electrical metering issue was and the exact financial harm that was suffered by a petitioner. Next slide. So the appeal also argues that the respondent was not properly served with the petition, and the hearing officer did address this issue in her decision. The petition was initially served on the real estate agent for the new purchaser. That was the person who had primary contact with the petitioner, had been the only contact that the petitioner was able to achieve because the new owner failed to comply with state law and provide the required notice of how to contact the new owner. Additionally, the respondent participated in the full hearing, did file a response to the hearing, so there was no deprivation of rights here on the respondent's part as a result of the petition being served on the real estate agents. Next slide. So both parties submitted responses to the appeal decision. The appellant submitted a response reasserting the fact that the petitioner didn't provide evidence that the exterior doors were previously self-closing or self-locking. Appellant also argued that they didn't have personal knowledge of the doors and to whether they were self-closing or self-locking, so they shouldn't be held to a standard of having to adhere to that. But the record does show that the petitioner did assert multiple times in the hearing that the doors did previously have a self-closing, self-locking mechanism. That was not questioned during the hearing by the respondent. So there does appear to be ample evidence to that effect. The appellant also argues that the award to the decrease in housing services due to the exterior doors should be reduced to reflect the fact that the doors were fixed on December 11th, 2024. You will note that the petitioner's response to the appeal decision claims that there has not been a complete fix. If they were actually fixed on December 11th, 2024, that is an issue that could be addressed in a compliance hearing, but there was not evidence in the record to that effect. The appellant landlord also submitted additional evidence with regard to the electrical meter. Once again, that we don't consider new evidence in the appeal hearing, but also this is an issue that is being remanded to the hearing officer, and that would be the opportunity for both parties to present additional evidence. The appellant landlord also raised an additional issue, noting disapproval that petitioner received assistance from the Mountain View staff in completing the petition. The Rent Stabilization Division, as you all know, offers office hours and housing help center for both landlords and tenants, and does help both landlords and tenants complete petitions and responses to petitions. Staff does not offer legal advice, but they do help people in answering questions on the petition, and that is what the petitioner testified to at the hearing. Next slide. So just fiscal impact, any decision you make on an appeal, whether you adopt the tentative appeal decision or modify it, could potentially lead to litigation, which would have a fiscal impact. But one purpose of the appeal process is to ensure that decisions are legally defensible, and so overall it reduces risk of additional legal process and legal expenses. So once again, our recommendation is you consider the tentative appeal decision and either accept the appeal decision or modify it with instructions to us, citing to evidence in the record.
Thank you very much. So we're now going to start with the appellant landlord. Please come to the lectern if you were speaking in person, or click the raised hand button in Zoom if you'd like to speak, and staff will temporarily promote you to a panelist. The speech timer will be displayed on the screen. You will have 10 minutes. So, Etan, please accept the promotion when it is available.
Hi, can folks hear me?
Yes, we can. Welcome.
Okay, good evening. I hope all of you are doing well. My name is Etan Fraser. I represent the appellant, I believe, in this hearing. That's 171 Castro property, the landlord in this case. Thank you for taking a moment to hear this appeal to the decision. I can see from the record that the response to the tentative appeal decision was received. Understanding that there may be some portions of that response that are more relevant for the hearing officer to hear on remand. There's really, a few issues that I'd like to discuss with respect to the decision. And they're, for the most part, laid out in the tentative appeal decision that I had submitted and that was received by your staff. I recognize that the language of the CSFRA defines landlord fairly broadly as any previous or current or future owner, and there is a connective chain that ties all of these folks who otherwise have no relation to each other, privity of contract with one another, to each other, so that when you purchase a property in Mountain View that is subject to the CSFRA, you are purchasing the entire chain of the property's history, whether or not you have anything to do with issues that have arisen in the past. You are still liable for them, which we can kind of discuss the merits of that as a matter of principle, but that appears in any case to be the law. And the reason why I'm mentioning that is because I just want to point out that the client that I'm representing in this case purchased the property on April 11th, 2024 with no, because it was an arm's length transaction. There's no previous relationship with the seller. Simply, somebody looking to fulfill one of their dreams and purchase a property in Mountain View, in part so that he can have a ground floor retail space to and put in a restaurant that he wishes will be of benefit to the entire community there on bustling Castro Street, full of restaurants. And he came up in this situation where there is a aggrieved tenant who had a number of issues with a previous landlord, none of which that he was aware of or had anything to do with whatsoever, yet is still subject to this jurisdiction and this venue to be defending himself against things that he never did. And another reason why I'm mentioning this is specifically with respect to this failure to maintain the self-locking, self-closing door situation. I would really just encourage each of you to imagine a scenario where you purchase a building and somebody is filing a claim with the government authority claiming that XYZ service once existed and now it doesn't, and therefore it's a reduction in service. And then having a government body affirm this claim and taking it as evidence. Evidence is, there's a bit of a higher burden to prove evidence than just saying something is true or saying something existed. So, for example, the petitioner in this case, and not referring to this petitioner specifically, any petitioner, could say that, hey, the house once had wings on it and it could fly through the sky and now it can't, and it's a reduction in service. This is obviously a ridiculous example, but the point being that the petitioner could say anything used to exist, but without providing evidence, video footage, photographs of this thing that they are saying that they lost having existed in the past. Simply saying that it was there is not evidence. And it is extremely prejudicial to people who purchase properties and can have a tenant basically saying that anything existed in the past. Where is the evidence that these things existed? There is no evidence. There's only claims that these things used to exist, and here is evidence of the fact that those things are not there now. That's easy to do. You can take a picture of an open door and say, hey, there's no self-closing door. Clearly there's not. You just took a picture, the door is open, it's not self-closing. But where is the evidence that is showing that that self-closing mechanism once existed? Where is the photograph that is showing that self-closing mechanism from 2018 or whenever the petitioner is claiming that that existed? So I find it very odd and very premature to rule that something existed when there is no evidence that the thing existed. There's evidence that it is not there at a certain point in time. That is not evidence that the thing existed in the past. So there's a break in the chain of connectivity to this logic that doesn't it's not comprehensible. And it wouldn't stand up in a proper court, but it has appeared to have some weight in this venue, which is confusing. And it sets a really, really dangerous precedent when anybody can just claim that something existed, which may have never existed, and then submit evidence of said thing not existing and be awarded money. It doesn't make sense. And I would hope that there are at least some members of this body who can understand, who do understand what I'm saying here. So that should be reversed altogether. There was no evidence. There needs to be a preponderance of the evidence that existed, but there is no evidence that self-closing or self-locking doors had ever existed. Secondly, on this point about the self-closing, self-locking doors, again, our position is that this should be thrown out. It sets horrible precedent, and there's no evidence that has been submitted that this ever existed at any point in time. Regardless of that, the appellant, my client, has made these installations on a certain date, and that was communicated in the tentative response. It sounds like this is relevant for a compliance hearing or something to that effect, presumably because this evidence was not submitted in the initial, prior to the initial hearing date. And with respect to this electrical issue, I would just like to reaffirm what I've already mentioned on paper, which is that there has, again, been no evidence submitted proving that this petitioner had paid any more. But in this case, it seems that the hearing officer understood that there was no evidence to that effect, and therefore now it's being remanded for some additional consideration. So again, I really struggle to understand the distinction there. These are both reduction in service questions, but one, gets remanded for lack of evidence, and the other one just gets an award slapped on it and still has the same lack of evidence. So I believe that there's a logical inconsistency in these two decisions. All being said, my client is a stand-up person in the community, has been willing to work with the petitioner from day one of this situation unfolding. And unfortunately, looks like he may have received a fraudulent estoppel certificate from the seller. And we will be dealing with that matter separately outside of this venue. But we do encourage this body to rectify what it is in control over with respect to this decision. Thank you.
Thank you. So now, respondent tenant, please come to the lectern if you were speaking in person. The speech timer will be displayed on the screen, and you'll have 10 minutes.
Okay. Thank you, committee. I don't know if I'll need a full 10 minutes, but with respect to the new owner not knowing anything about coming into this situation, my experience throughout this whole situation was that the building sold twice in the last 5 years or so. And with each change, there was a reduction in services with respect to the security of the building, but also with respect to my ability to even communicate with anyone about what I need or what needs to be fixed. With the original owner, I don't know if maybe you do know, Al Jennings used to own that building, very proud member of the community, very proud of his building. Sorry, let me refocus. The question is, why should that client be liable? The question is because if this guy's client is not liable, then all of that liability falls onto me, and I'm just barely holding it together, paycheck to paycheck, trying to be in this community. I'm a teacher. And if the client is not liable, who's liable? Also, it appears that the management company was actually working with the immediately previous owner who owned the building for a couple years, flipped the building, sold it to this guy's client. The property management company was working with them, so there was some form of continuity, at least there. And as was brought out in the hearings, there was an estoppel certificate, and I provided evidence where I was trying to work with the owner. Hey, fix my problems, fix my electricity, fix the locks, and I'm ready and rearing to sign that estoppel for you. And in the 11th hour during our hearings, an estoppel with a signature that wasn't mine was produced. And with respect to the electricity situation, that's another situation where in the 11th hour, I know that the committee is not hearing any new evidence, so what was sent over email is not being entered into evidence, but it's another case of a fraudulent document coming in the 11th hour. I was there when the electricity was fixed, and Anchor Property Group had at least 2 people and at least 2 phones out recording when the electrician opened it. And so I'm wondering if he was going to send evidence right at the very end, at the last moment. Why wouldn't he have sent the video of what happened when they opened the terminals on the electricity? As to the claim as to whether or not, I'm just making up that there used to be self-closing and self-locking doors and that this may set a bad precedence. Self-closing and self-locking doors are building code. And I mentioned Al Jennings before. He was a proud owner, community member. He had the museum downstairs. They had their lock shop. He was a locksmith. He was a locksmith. Of course it had self-closing and self-locking doors. Not only is it building code, it's just plain common sense security for a street-level entrance on a street as busy as Castro Street. And when I moved into the place, that he told me, if there's ever an issue with the doors, let me know, because they had issues before. And as I testified and submitted evidence in the hearings, I had a violent break-in into my apartment while I was home. Mr. Fraser claims that the new landlord has been willing to work with me. I mean, I'm going to give him the benefit of the doubt. I actually think the new owner probably is a nice guy. He sounds like a cool guy. He wants to build a restaurant downstairs, but he's not involved in any way. It's his representatives, and it's these other representatives, whether it's the real estate agent or the property management group or whatever, that are producing fraudulent documents. They're trying to make it uncomfortable for me, is what it seems like, to get me out there. So. The new landlord's probably a great guy, and I hope there's a way to heal the relationship after all of this is over, but it's not my fault if his help is not doing the right thing. And, again, to the claim that he's been willing to work with me and fix issues immediately, they fixed the doors in December. And the reason they fixed the doors in December is because the fire department finally wanted to come do an inspection, and they fixed the doors like the day before, but they didn't fully fix the doors. And the hearing officer understands exactly what wasn't fixed fully, which is that on the inside, the lock can be disabled by any one of the short-term tenants that are coming through constantly. And so, somebody out of their desire for convenience will leave that unlocked, and you can just walk right in from the street level. So that's what I mean when I say that it's not fixed completely. And that's what I mean when I say, the landlord hasn't really been working with me. It wasn't until the fire department came to do the inspection that they finally did that. And then finally, there's this question about the electricity and preponderance of evidence. The real question that the hearing officer still has is, was it a mix-up in electricity, or was I paying for both? As I testified, they had done a lot of renovations. They took one large unit, split it into two, and a couple years later, when things aren't adding up, I discover that I'm paying for two units, my unit and this additional one with all of the updated appliances and everything like that. And in our hearing, when we first started the hearing and the electrician had just come and fixed the problem, I said, okay, can we agree that, the electricity thing happened? And Mr. Fraser said, yes, there was a mix-up. And I didn't realize that that was a strategic term at that moment. And I still testified that this was not a mix-up, that this was me paying for an additional unit. I think that's all I have to say for this part of the hearing.
Right, thank you.
Thank you.
We now have 5 minutes for the rebuttal from the appellant landlord. Etan?
Yes, hi. Can everybody hear me again?
Yep, go for it.
Okay, I'm just going to address a few things that were said. I guess I'll kind of work backwards. I just want to maybe personally this idea that a term was used strategically to create some confusion. That's just not the case. It's somebody can understand something to mean one thing, another person can understand something to mean something else, and that's just not how I conduct myself or would conduct business. And Daniel, I've always mentioned this to you before. Both the landlord and yourself both are in this community. We have to all get along during this process. When this process is done, I would just encourage you to not assume that there is any kind of underhanded strategies that are going on to try and disadvantage you or this hearing. That's just not the case. Number two, I don't understand this point about the fraudulent document. I'm not quite sure what it is that you're referring to, but once again, I do not submit fraudulent documents. So I actually don't even know what that's referring to, but I would strongly encourage you to avoid making statements like that. Why there isn't a video recording submitted, I'm not quite sure where to go with that one as well. I'm not aware of any video recording. I'm not sure how you would be aware of any video recording. There's no kind of ongoing monitoring of every little thing or repair that's happening on the property. No, people just don't do that. They're there to work and to fix a problem, not to record themselves fixing a problem or something like that. I also want to discuss this building code thing. I think, folks who are not in the profession of building, these things get very kind of convoluted, but it's really important to stress that the building code is updated by the state of California every 3 years. This building was built in the 1900s. There are certain aspects of building code that will retroactively apply and others that will not. So the idea that something is in today's 2025, building code does not mean that all buildings in the city of Mountain View have to update everything to comply with 2025 building code. That's just not how it works. This relates to new buildings and certain renovations that meet a certain, threshold of having to be updated to new building code. It really dates back to when you get your planning approval. Your planning approval, or your building plan approval dictates what building code you're subject to. This building was built in the 1900s, before there was even the building code. I believe Mountain View used the San Francisco's semblance of a version of the building code at the time. So let's just be clear about that. The fact that the previous owner was a locksmith, is not evidence that there was previously self-closing, self-locking doors. The fact that it might be to some people common sense that something like that exists is not evidence that there was previously self-closing or self-locking doors. So I would just like to reiterate that we have no belief whatsoever that such a thing existed. There's no evidence that has indicated that such a thing has existed. And once again, as far as this electrical meter issue, what our electrician has told us is that there was a swap, that Daniel meter was connected to one unit, and that meter was connected to Daniel's unit, and the meter that was connected to Daniel's unit was being paid for by the landlord, because the landlord has duly approved short-term rental permits for all the other units in the building. For this historic building that sits on Castro Street, and as folks on this committee are well aware, it's not always easy to do things to facades, exteriors, what have you, of historic buildings. They have a historic designation for a reason. So with that, just thank you for considering this reply.
Thank you. And now we have 5 minutes for rebuttal from the respondent tenant. Please limit your comments to rebuttal rather than repeating information already presented.
Okay, I'm certain that that self-closing and self-locking doors has been building code for many decades. And as to the comment about submitting fraudulent documents, I give Eitan the benefit of the doubt as well. I don't think that it's necessarily him. He's there serving a role and doing his job. But where those documents came from with respect to Anchor Property Group and whatnot, and who they hired to fix the condition, I am willing to testify under oath about what I saw when it was opened and my qualifications to understand what I saw as well. That's all.
Thank you. So now we will move on to questions for staff. I'll wait for the members to set their screens. Member Balch.
Yes, hi. A question for staff. I'm looking in the tentative appeal decision document, and regarding So regarding evidence or let's say quality of evidence in terms of the self-closing doors, there's a quote here that says the petitioner writes, they painted over the hydraulic door closer downstairs, which made it stick even more, and removed the hydraulic closer from the back door. My question for staff is, was this the total information that the hearing officer considered? There's a statement that they painted over a hydraulic closer, meaning that there is a hydraulic closer that someone could have provided a picture of. Were any pictures submitted, or was this sentence the only information that was considered? And if so, would it be reasonable for the hearing officer to say, well, if it's there, I want to see a picture?
Primarily, the hearing officer relied on the testimony of the parties with regard to this issue, which is valid evidence. There were pictures of the door, but I do not believe there were pictures of a hydraulic closer. I do just want to note that the petitioner testified multiple times during the hearing that previously the doors had self-closing, and there was no cross-examination as to that issue by the respondent, and no counter evidence submitted.
And then just to follow up there, if the respondent had done a cross-examination and basically challenged that or questioned that, would that have any significance?
So the hearing officer's job is to weigh the credibility of the testimony. And so that would have been part of the hearing officer's weighing of the evidence, depending on whether there had been a response to such a question. But she did weigh the credibility of the petitioner in making her decision.
Thank you.
All right, thank you. Member Cox.
Yes, I just want to make sure I understand how this thing with the estoppels works. I mean, because, I mean, we've had some questions about, you know, legality under the CSFRA and what things a tenant is allowed to waive and can't waive, okay, in terms of his rights. And so, reading between the lines, it sounds to me that if a landlord gives the tenant an estoppel document and he signs it, okay, then he legally can waive his rights, you know, to what happened, you know, based on during the tenure of the previous landlord. Is that right?
So that would be an issue that we would have to examine in each case, but the CSFR does say that tenants can't waive their rights. In this issue, the issue of whether the estoppel would have constituted a valid waiver was not addressed because the hearing officer determined that the estoppel was fraudulent, that the petitioner had never signed it, and there was ample evidence that the petitioner had said he would not sign it.
Okay.
So we never got to the issue of what if the petitioner had signed it.
Okay, thank you.
Thank you. All right, I'll take a quick turn. All of the participants in the hearing were sworn in?
Yes.
And sworn testimony is considered evidence?
Yes.
Both in
Yes.
our hearing procedures and also generally, yes?
Yes, that is correct.
And there was an opportunity to respond or rebut within the process to submit, as a form of submitting evidence that, like, to rebut the testimony of the petitioner.
Yes.
Okay.
The hearing officer gave both parties an ample opportunity to respond to what the other party said. This actually was a fairly long hearing. It was conducted over the course of 2 different days. So there was opportunities for the parties to gather additional evidence based on what they had heard in the initial hearing, and there were opportunities to question the testimony.
And then, any more questions for staff? No? All right, any questions for the appellant? Yes? Member Cox?
So let's see, the appellant is the landlord, okay?
If you want to ask questions of either.
Okay, I'll ask first the question to the landlord. So, I mean, do you concur with what Karen just said, okay, about that you did not offer any testimony during the hearing, you know, with regard to whether or not, you know, the self-closing door feature actually existed during the time of the previous landlord's ownership?
Yeah, so thank you very much for that question. I having not rewatched the recordings, I cannot say that I concur with that. What I will say is that from a practical standpoint, from a landlord who purchased a property on April 11th, 2024, how can somebody in that position, and I'm sorry to answer your question with a question, but I think it's just an important hypothetical, how can they possibly provide evidence that the condition never existed unless they were able to go back in time and walk in the building? And this is the exact reason that my argument today is that this whole approach is incredibly prejudicial in this circumstance. If the current landlord had owned the property for the last 20 years, that would be a situation where, hey, maybe there are some photographs that we have, you know, just from the owner taking pictures around the property, and we could point and say, look, there it is, or there it isn't. But there is no way that, as a respondent in this situation, that we can respond to something like that with any, because the landlord didn't own the property. The landlord has, you know, it's not something that this landlord had the ability to respond to. And for that reason, this is a very, very dangerous and problematic situation.
I believe Robert's question was answered.
Yep.
Member Keating?
Thank you. I have an additional question for staff. So if we do remand on the issue of the utilities, then new evidence is allowed, and that would include providing historic bills before and after the remodel, for example?
Yes, I mean, it will be up to the hearing officer to determine what she needs to make the decision, but that would be one option.
All right. Any further questions for either staff? Oh, Member Cox.
You didn't finish your sentence, but I do have something for the tenant. Can I do that now?
Please.
Okay.
Would you like to first select?
So just to make sure, I mean, I did watch the recordings, you know, as long as they were, and I did hear you say twice, okay, you know, first time you did raise the issue about that there had been a change, okay, in the self-locking doors. And in particular, what I heard you say, first you had said that, you know, and you had said that it was on the basis of renovations that were being done, okay? And then the second thing I heard you say, clearly you repeated it, okay, in the hearing that yes, there had been a change. So am I getting you right there?
Yes.
Okay.
I also did submit photos and I believe video. When I initially submitted my evidence, there was a ton, and they told me to trim it down. So I know at least many photos got through that do show the hydraulic mechanism.
You're talking about what were in your photos?
Hydraulic mechanism downstairs.
Before or after the change?
After the change.
And what did you show in your photos?
Mostly what I was showing was that the door was constantly ajar.
Okay.
The door was constantly
so that there
ajar.
was a hydraulic mechanism, but that it was not working appropriately.
Correct. Okay. And the other thing that I focused on was that they installed a key code on the downstairs that can be disabled from the inside with just a twist of the lever.
Okay, and then one more question. During your testimony, you know, to the hearing officer, I mean, you know, you went into great detail about how someone had come in and had, you know, actually damaged your front door by kicking it in?
Yes.
Okay, and I guess one thing I didn't hear in the testimony is it seemed like you were assuming that that was somebody who came in off the street, but do you know that it wasn't another tenant that did that?
I know for a fact that there were no short-term tenants at the building at that time. It was, I'm the last holdout from when those renovations first occurred, and this happened right before the previous owner had bought in like 2021, I believe it was, and I'm certain that he came in off of the street. He was experiencing some kind of stimulant psychosis, and the police actually took me to where he had been arrested to drive by and identify him. And I read the police report that he was a transient from another state.
Okay, thank you.
There is a police report in the record.
Okay, thank you.
Thank you. All right, last call for questions. All right. So the RHC will now deliberate. It would be appropriate at this time to entertain a motion to adopt the tentative decision, after which time such motion can be discussed by the RHC. Member Cox?
There we go. All right, I will make a motion that we accept the tentative appeal decision in its entirety. Let me go. But, you know, for this one, this has been a particularly, motion. Okay. So this was, honestly, this has been the hardest one I've had to listen to since I've been sitting on the RHC. I mean, both because it involves not only, you know, matters of law, but substantial matters of fact. And so let me go through my reasoning as to why I agree with the tentative appeal decision. I mean, the first thing has to do with the issue of the self-closing, self-locking doors, and I think that's actually the hardest one because, you know, I mean, here's the thing. What I try to get my head around the idea is that what kind of evidence could have been provided that would have made the difference? I mean, you know, and if we look at the circumstance here, we have a tenant here who is the last person who is a regular tenant, okay, in an area where all the other units are being Airbnb'd, okay? So now, I mean, in terms of photographs that could have been provided, I think, you know, what he said is a reasonable amount of evidence to show. You know, obviously, it would have been nice to see it before, but who takes pictures of a problem before it happens? I mean, that's not a reasonable thing to expect, okay? And so, I mean, you know, the only thing that I think that could have really added to this is to have some other person come in and give testimony as to whether or not they recognize that a self-closing door feature to have either been there before and not working afterwards, or that, I mean, you know, it was never there before. And it's hard to do that because of the change in the ownership and because of the fact that if he's the only regular tenant there, he can't knock on the door of somebody else and have them come in, okay, and testify for him. So, I mean, you know, so basically, you know, as I sat and thought about this, I was saying, like, you know, well, okay, so we're only asked to determine things based on whether the hearing officer had determined her decision based on substantive evidence. It isn't preponderance of the evidence, which is a stronger standard. But, I mean, I felt like I feel like we have to decide this by the preponderance of the non-evidence, okay? But having made that joke and wanting to go further in serious conversation, I really do think that, you know, in weighing the evidence, I think it's reasonable to assume that the petitioner had presented reasonable evidence, you know, making his point, and that there was ample evidence of an ample opportunity over the many hours of this hearing for the the appellant, or his lawyer, okay, to raise, you know, other testimony, bring somebody else in or whatever. And he spent a lot of time talking about things like whether this is a habitability concern, what's reasonable, and all those kinds of things, but never directly addressed the question or brought testimony at that time. And we have to make our decisions on what's in the hearing record. So that's why I'm okay with part one. And if my computer would quit turning off, give me just a second to get back on the screen. Part two, I'm okay with the remand because I think this is really very confusing, and I think that staff raised an important point about we just don't have enough evidence in the record right now to figure out exactly what happened and who's responsible and whether there was a reduction in services or not. Okay, I mean, you know, clearly there was a mix-up, and I think that's something that all the property owners, the property owner and the petitioner agree, but I don't think that there's enough evidence there to say whether or not, you know, that ended up causing him. I think it's likely that he probably paid more, but I'm, you know, if staff thinks remand, I'm okay. I'm okay with remand. I mean, you know, I saw the graphs. I thank staff for coming back with the idea of, I asked the question about, you know, why his usage graphs aren't as good as having electric bills, and it was a good answer. The idea is electric bills show who paid for what, okay, and usage just shows you usage, and it's not clear what the usage is. I mean, I get the petitioner's point that there were spikes in the usage, but, you know, on the other hand, you know, he also testified the fact that he had visitors coming in at some points. Okay, so that could spike usage on his own unit, so I don't know. And I think the prudent thing to do is just send it back. So there's that. And then the last one, yeah, I completely agree with this. I mean, you know, the petitioner did everything that he could. I mean, given the confusion of the constant, I mean, you know, the change between landlords. I mean, you know, to make his point clear, he had gone on with this for years with the previous landlord. And, you know, and so, I mean, you know, he worked in good faith to try to communicate that information to the existing landlord. I heard a lot during the testimony of the landlord's lawyer saying that this landlord's a good guy and everything like that, and I don't question that a bit. I mean, I heard everything in the testimony that seems to be, but that's not the point. The point is when you buy the building, you know, CSFRA makes it very clear that the idea of landlord spans the period when the tenant is in there, and then you buy the building, you buy whatever problems, you know, I mean, the previous landlord had and are unresolved. I mean, you know, and so, I mean, you know, I heard a lot of testimony from the attorney that he questions whether, you know, whether the CSFRA, you know, is, as it's written, you know, is self-contained and legally justifiable to justify, you know, these kinds of decisions. I mean, honestly, you know, the constitutionality of the CSFRA and its provisions, that's not a matter for the hearing officer to decide. And so we've had several cases of this. Basically, you bought it, you own it, and the problems that go with it. And so I completely agree. And having said all that, I will yield the floor.
Thank you very much. So motion to approve the tentative appeal decision in its entirety made by Member Cox, seconded by Member Keating. Member Balch.
Yeah, thanks. There's a lot here. First of all, I think it's really important. I think I take the statements and the hearing officer's work at face value. I'm not going to read malice. I don't really appreciate when there's even things that are approaching ad hominem comments, and I'm certainly not going to read into speculating on what anyone's intentions were. So I assume no malice, and I take the testimonies and evidence at face value. We're also not code enforcement officers. I'm certainly very well aware of the difference between conforming and code compliant, but it's really irrelevant because we're not code enforcement officers here. Committee member Cox talked correctly about the CSFRA, and it's even not even the CSFRA, it's actually California law, that the purchaser of a property assumes all liabilities. Now, there's an argument that that could be prejudicial. Would I buy rental property in Mountain View? No comment. But that is an argument, though, for the courts. I actually, you know, since we actually addressed this pretty much every meeting of this committee, I actually researched this evening just to have my facts straight. And the U.S. Supreme Court upheld Escondido, California, back in, I think, 1992 or 95, one of those years. But in the 90s, the California Supreme Court upheld various other types of rollbacks and rent control provisions going back to the 70s and 80s. In the last couple of years, there was a case in New York that was not heard by the Supreme Court. So yes, to Committee Member Cox's point, we're not going to take the place of the U.S. Supreme Court. If there is a claim that the CSFRA is unconstitutional, let's see it in court. Let's see it go all the way. But that's not something that we're going to be able to adjudicate here or expect the hearing officer to adjudicate. There was a term used about arm's length transactions. As someone who owns real estate, it's scary as heck to go into a transaction without doing diligence. And so we all have to do our diligence anytime any of us buys anything, whether it's a car or a house or a rental property. That's just for our own protection. The point about credibility of evidence was addressed, and there is a reasonableness threshold that I believe has been passed with the hearing officer's judgment on the first topic about the self-closing door. I also do agree that it seemed very clear that there should be more detail on kind of a general claim for electrical overbilling or misbilling. Presumably there should be evidence of looking at the wiring and how is the wiring now, how might the wiring have been modified. That has to be looked into. So I do appreciate that the staff has recommended remand, which I support. The issue about improper notice, again, I think we all have to be very familiar with California law and the requirements of noticing tenants after a change in control. And I believe that that's actually a longstanding provision even outside of the CSFRA. And then there was another comment which I thought was interesting about the Mountain View staff providing advice to the tenant, and the staff does note, which I think we all understand, that there's a difference between procedural advice on how to fill out a form and legal advice, and the staff of Mountain View is not providing legal advice. So I think, look, I think diligence is super important for all of us, no matter what position, no matter what side of the table we're on in any transaction. And if there is a concern about an improper judgment or unconstitutionality, bring it to the courts and let's see it happen, or bring it to the voters and let's see the law changed. But those are both way outside the scope of the Rental Housing Committee. So I also approve the staff's recommendation.
Thank you. Member Keating.
I would just like to make one comment about the value that the rental community, or our city, gets from the requirement that a subsequent landlord is responsible for the actions of the prior landlord. Because if that wasn't there, then we could be seeing people sell properties in order to avoid responsibility. And that would not be beneficial. Thank you.
Thank you. And I will take my turn. I strongly agree with my colleagues. I think that it would set a bad precedent if you were able to acquire just the assets but not the liabilities through a transaction. I think that would void the rights of the residents of the city, and I think that would all have its own harms. So due diligence is very important. I think that the fact that the agent was the realtor who was helping with the transaction shows that there was a process in this, in the acquisition of the property. There was a point of contact in this case, and that is, I believe we've done presentations and things with realtors who operate in Mountain View, discussing the CSFRA and its implications for sales, right? So I would also affirm everything except for the electoral issue. And I think that is something that I can easily see evidence being available to help make a judicious decision. So I think that remanding that back to the hearing officer is a solid move. Any more comments before we vote on the motion on the floor?
I thought it was. No?
Maybe you have to hit the button on the thing.
Which one?
It's on the other screen.
Okay.
Remember with us.
I did. I pressed the button. Oh, there I go. Okay. So. Oh, sorry, guys.
Okay, Member Rosas.
Thank you. Sorry about that. So I agree with my fellow committee members here, and I'm not going to expand too much on that. The only thing I would like to bring to everybody's attention, at least what really brought to my attention and why I'm going to vote the way I'm going to vote, is the fact that there was some, in that it was ample evidence that there was some doctoring of some signatures, which that definitely is a huge concern for me, because I don't think that should be allowed in any situation. So that's all I wanted to say on why I'm going to vote the way I'm going to vote.
Thank you. I believe it's now time to vote. All right. The motion to accept the tentative appeal decision in its entirety passes unanimously. So we can now move on to item 5.2.
Yes, so item 5.2 is another appeal of a hearing officer decision. This is on petitions numbers 2324 0083 and 0084. Once again, the recommendation is that you consider the tentative appeal decision and either accept it or modify it with instructions to staff, citing to evidence in the record. Next slide. This is just the procedure again, which we've already been through, so I think we can move on. So this was a tenant petition for a downward adjustment of rent. The petition was based on 3 issues: failure to maintain a habitable premises, a decrease in housing services and maintenance, and unlawful rent. Next slide. So the petition originally sought a downward adjustment based on habitability and decrease in housing services related to a variety of issues, including sliding glass doors in the shower that didn't close, vinyl flooring in the kitchen that was lifting up, dirty carpeting, and porcelain on the bathtub that had peeled, resulting in mold. The petition was also based on the respondent demanding and retaining unlawful rent because the prior owner had imposed several rent increases while out of compliance with the registration requirements. Next slide. So this is just the timeline of the petition process and the hearing process. Next slide. So the hearing officer's decision covered a lot of issues. During the hearing, the petitioner withdrew some of his requests, including the requests related to the shower sliding door, the kitchen floor, and the peeling bathtub. Those issues had been rectified prior to the hearing. The hearing officer did find that the petitioner had met his burden of proof with regard to the landlord's failure to replace old, dirty carpeting that was also moldy. The hearing officer ordered a rent refund of $190 for the period from June 11th through June 30th of 2024, and an ongoing rent refund of $300 per month until the carpeting was replaced. Next slide. The petitioner also met his burden of proof that the landlord has demanded and retained rent exceeding the lawful rent. The prior owner had imposed an unlawful rent increase in 2018 of 5.7%, and the prior owner or the current owner had failed to properly register the property in 2021, 22, 23, and 24, but had imposed rent increases in each of those years. And also that the carpet situation had constituted substantial noncompliance. So the hearing officer ordered a rent refund of $14,371.89 with regard to the unlawful rent, and determined that the lawful rent is $1,448. Next slide. So the appellant respondent raised 2 issues on appeal. The first issue was that the hearing officer erred or abused their discretion in concluding the landlord was a proper party to the petition because it was not equitable to hold the landlord liable for the prior owner's violations, and that the hearing officer's decision that the landlord was liable for unlawful rent violates due process and equal protection under the 14th Amendment of the U.S. Constitution. Next slide. The tentative appeal decision affirms the hearing officer's decision in part and remands it in part. The tentative appeal decision finds that the hearing officer didn't err in finding respondent was the proper party to the petition and could be liable for the prior owner's noncompliance. The respondent falls within the definition of landlord, which we've discussed in the past. That definition specifically includes successors in interest. The respondent also failed to assert any equitable defenses at the hearing or on appeal, and even if they had, the hearing officer does not have authority to address equitable issues. The respondent did not demonstrate why it was entitled to equitable relief. There's no evidence that the respondent made a good faith effort to inform itself of its obligations as a landlord or to determine whether the prior owner was in compliance. Next slide. And also, the hearing officer's decision to hold the respondent liable doesn't violate the respondent's constitutional rights. The respondent did not make any arguments for why its ownership of the rental property and its operation of the rental housing business was insufficient to establish that the rental housing committee has jurisdiction over the respondent. And the respondent misunderstands the application of fair play and substantial justice legal standard. Next slide. However, the hearing officer's decision does contain some errors that may impact the outcome of the petition, which is why we are recommending a remand. The remand issue is being raised sua sponte, which is one of those fancy legal terms, which basically says you would be raising it on your own volition, not because one of the parties raised it. The hearing officer's decision incorrectly states that the respondent acquired the property in May of 2024, although there's evidence in the record in multiple instances that it was actually May of 2023. The hearing officer concluded that respondent learned of the carpet issue in June of 2024 and based the award on that. But the record demonstrates that the petitioner actually informed respondent in November of 2023 of the carpet issue. So we're recommending a remand on the carpet issue to harmonize the finding of facts with the evidence of the record, and if appropriate, to correct those findings and revise the award. Next slide. So once again, the fiscal impact, there could be a fiscal impact if your decision was taken to litigation, but the point of the appeal process is to mitigate those risks. Next slide. So we are recommending that you either approve the tentative appeal decision or give instructions to staff of any modifications citing to evidence.
Thank you very much. So now is the time for the appellant landlord. I believe it is Jill. Please raise your hand and you can be promoted to a panelist. The timer will be displayed on the screen. You'll have 10 minutes.
I actually don't have anything to add. I just listened to the whole last hearing. So we did have an attorney that was representing us, but I'm pretty clear on the way that everything states. So I don't have anything.
All right. Thank you very much.
Alrighty.
So we now have 10 minutes for the respondent tenant. Please, if you want.
Oh, look at, there's Brian. There's our attorney.
Yeah, can you guys hear me?
Yes.
Oh, okay. Jill, do you still want me to say something?
I mean, I don't think that they were really clear in the last hearing. I don't know how much of it you were able to listen to.
I heard the whole thing, and I would agree with you. I would make just one point on the equitable relief and the equitable nature of it, and then I'll kind of leave it at that, if that's all right with everybody.
It's your 10 minutes.
Thank you. So the tentative does talk at length about the fact that we're essentially asking for an equitable remedy. It indicates that the hearing officer doesn't have the authority to fashion a equitable remedy. I would just point out, just maybe food for thought, in actuality, what was ordered, the disgorgement of the overpayment of rent, the illegal rent, if you will, is an equitable remedy. And so that's exactly what the hearing officer was doing. So this, to say that they don't have the authority to set out equitable remedies is not accurate. And there is a recent Supreme Court case that discusses equity and legal remedies and the difference between the two, and there's a pretty good history of it. But it makes it pretty clear on what's equitable and what's a legal remedy. And that was the Securities and Exchange Commission versus Jarsky, Jarkesey, so I guess it's Jarsky. That was a June of 2024 decision. And just to put it out there, a equitable remedy is something that is designed to establish or reestablish the status quo, to put people back where they should have been. The repayment of the illegal rent as ordered is a quintessential equitable remedy. It's putting the tenant back in the position where they should have been. And that's what that's what's being done here. So this is equity at work, as opposed to a legal remedy. Legal remedies, as cited in that case, and this report discusses it fairly simply and straightforwardly, is designed to punish. Those are penalties, fines, stuff like that. It's not what's going on here. The money that's been ordered to be paid to the tenant are not penalties, are not fines. That is an equitable order. Therefore, the request that equitable considerations be given as requested in the appeal, I think is appropriate. And it's something to look at. I understand, as Ms. Hammond pointed out, the position that the city has in regards to the appropriateness of having the landlord's definition be as broad as it is, and the reasoning for it. I understand that you want to have or avoid landlords selling property to get rid of their liability. I would submit selling of a property in and of itself in this scenario does not get them out of the fire, so to speak. The tenant could still sue the former owner for those illegal rents. They still have that ability. So selling it in and of itself does not get rid of the problem, so to speak. So the tenants have rights above and beyond the CSFRA that they can avail themselves of if an improper rent increase was done. So we do have, and that's the whole point here. We have a jurisdictional type of issue, and certainly I do, international shoe was referenced, and the traditional notions of fair play. And that talks about minimum contacts. You know, if a defendant or a party has minimum contacts in a jurisdiction so as to justify a court having jurisdiction over that party. Certainly a minimum contact exists now in that the owner owns this property and is running it as a business. Certainly that's a minimum contact, but we're talking about some of these actions, some of the demands for rent and the retention for rent occurred even before this owner existed, this LLC even existed. So when these acts were committed, there was no contact whatsoever with Mountain View at that point. So again, I think as moving forward and in looking at this CSFRA, equitable considerations should be taken into account. I think the ordinance itself gives hearing officers explicit equitable powers in ordering restitution and disgorgement of illegal rents. And so therefore, certainly equitable defenses should be considered and are appropriate. And again, no, that's all. I think that's a pertinent point in looking at the tentative and as it addresses this, whether or not equity is appropriate here. I think it most certainly is, given what is being ordered and what the essence of those disgorgements are. Thank you.
Thank you. Would the respondent tenant like to speak? If so, please approach the lectern.
Good evening, everybody. Yeah, well, go closer. Yeah, good evening, everybody. Yeah, well, when I filed a petition, I was been requesting this to the in-house manager, which are two people. The first in-house manager died, and there's another one who was still alive and taking over as an in-house manager. So I've been requesting this for a long, long time until on 2023, I requested it to the Vasona management, and one of the manager there gave me a go signal that they will replace my carpet and everything. But on the 2024, when I come back to them, which I have it on file, the email of both manager, that the second one is rejecting my request. And now they want me to pay on top of the rent of $150 per month rent just to replace the carpet. Okay? So on that time, I never know that these people or the landlord is non-compliance. I just found out that they're non-compliance. If I knew that before long then, I could have come up already and complain about it. I've been there for 15 years now, and that carpet has been there since I lived on that unit. So it's not me who is not in compliance and not registered on the city. So I just found out that one, that there's a ruling that you have to register yourself and be compliant to raise the rent. Since then, they were raising my rent, and I'm still paying it on time until last November, they raised the rent again. So that is my case. So.
All right, thank you. We have 5 minutes for the appellant landlord to rebut any statements made by the respondent. Please limit your comments to rebuttal rather than repeating information already presented. Jill or Brian?
I have no rebuttal.
All right. Yep. So we can move to questions for staff. Do any RHC members have questions for staff? Any questions for the appellant or respondent? Member Cox.
This is a question to the tenant. Could you come up to the microphone? So I just have a question about, with respect to the carpeting, during the hearing, there was the issue of, the landlord had asked you the question about, he said, the new landlord said, well, fine, I can replace it, but you had said that, it's not a convenient time for you to replace it right now, okay? Because, that, you want to wait until the holidays or something like that. Did I misunderstand that? Or?
No, sir. No,
okay,
sir.
Tell me.
Yeah. When I requested to replace the carpet, that was 2023.
No, I know that.
And the 2024, they send the rental housing committee over there at Escuela already requested a fire inspector before they found out what are the problems on that unit. Mm-hmm. And that's the time they start fixing it until the carpet hasn't been done until the last hearing of my petition.
Okay, but my question to you is, did you ask for a delay in fixing for the carpet, so that it would be more convenient for you?
On the first time, on the 2023?
No. I mean, like when they finally decided that they were going to fix the carpet. Okay.
No, I did not, because that's the time I have to leave the country, and I just lost my mother. That's why I have to leave the country. And I said, go do it now. And then they said, okay, we'll send the maintenance and see if they will order the carpet, blah, blah, blah. And that's
okay,
it.
So
until they replace it before the holiday of, I think somewhere in November 11.
Okay, so just to make sure I understand you, you're saying now that you did not ask for them to delay to fix the carpeting to a time.
I did on 2023 when I first requested it.
Oh, when you first requested it?
Yeah, when Corey Payne approved it, and then on the 2024, they declined it.
I see. Okay, thank you for the clarification on that.
Any more questions from committee members? Well, then now would be the time for the RHC to deliberate. it would be appropriate at this time to entertain a motion to adopt the tentative decision, after which time such motion can be discussed by the RHC. Member Cox.
All right, this is an easier one. Yeah, I'm going to make the motion to, you have motion, did somebody, did it there for me. Okay, to accept the tentative appeal decision in its entirety. Basically, it comes down to, for me, I mean, as it was recognized during testimony, I mean, like, the key thing that was being appealed, was this issue of whether or not the current landlord is responsible for the prior landlord's actions or inactions in terms of, establishing, correct payment of correctly what the rent should be and whether there's a reduction in services. And so, yeah, I mean, they are, okay? And so, I mean, the things that are being appealed here, they just don't have any weight. And so that's why. Now, for the issue about errors in the, and contradictions in the hearing officer's report, yeah, my request back to staff is just that, I mean, in the initial thing that I saw, they said, oh, there's these errors, but didn't say what they were. I always appreciate if you can say directly at that point what they are, because while you're writing that, I'm sure you know that. I spent some substantial time trying to figure out exactly what you're referring to, and then in further things, you actually pointed out what they are. And so that's good. Now I understand, and I can be confident of that. And so I also agree that that should be remanded back, okay? So, yeah, that's that. And the only other thing I would have to say is that, yeah, thank you for clearing up the issue about when the question came about, asking for a delay in fixing for the carpet. Since it wasn't immediately upon the time when it needed to be fixed, then it's not an issue, because I was a little bit confused about that, thinking that, the tenant had asked for a delay, and then why is it the landlord has to pay during that period. But now I understand that, so thanks for clearing that up. So that's all I have to say.
All right, motion to affirm the tentative appeal decision in its entirety made by Member Cox, seconded by Vice Chair Ma. I'll take a second. To explain why I'm also going to vote for this. I think that when it comes to fairness under the law, it is important to get the numbers right, and that means getting the dates right so that the calculations are all have a firm basis. And so I agree that remanding this to the hearing officer is a good move, so we can make sure that all of the decisions that come through under the CSFRA and MHRSO are well-founded. And if there's a mistake, we have the power to fix it. Member Keating.
Thank you. I'd like to ask Committee Member Cox to clarify what you learned in the response from the tenant.
Yeah, there we go. What I learned in the response from the tenant was that during the hearing officer recording, I heard the issue coming up. He had said that he was very happy with the new landlord, that the new landlord had solved all of the problems immediately except for the carpeting, which hadn't yet been replaced, but that there was some issue with regard to should the carpeting be replaced, immediately or at some later time. And I had thought that referred to the idea that, I had misunderstood that, because I took that to mean that it was the tenant who was standing in the way of the repair. And then if that had been the case, I would wonder why the hearing officer would continue to charge the landlord for not fixing the problem when it was the tenant who had asked, for the delay. But he's pointing out right now that he had only asked for the delay on the when he first raised the issue, and that later on, this secondary landlord then denied him, okay? And so the idea of asking for the delay didn't pertain to the current landlord. And so, I mean, he wasn't standing in the way of having the repair made, basically. So that cleared up any misunderstanding I had about why the hearing officer would allow, the extra money for the carpet, to be charged back to the landlord till it was fixed. So.
Thank you.
All right, any more deliberation? I think it's time to vote. All right, the motion to accept the tentative appeal decision in its entirety was passed unanimously. Which means I get to find the original script. Would anyone like to take a break before moving on? Yeah. All right. So we will recess for 5 minutes and be back at, let's go with 8:50.
Going live in 5, 4, 3, 2, 1.
Welcome back, everybody. We will now move on to item 6.1, our study session. Proposed amendments to Chapter 13, Utility Charges of the Community Stabilization and Fair Rent Act Regulations. Public comment will occur after the presentation item and committee questions. We invite you to submit a speaker card now if you know you would like to speak on this item during public comment. We will begin with a presentation from staff.
Thank you, Chair, and thank you, Committee. Item 6.1 is proposed amendments to Chapter 13, Utility Charges of the CSFRA. And the purpose of this staff presentation is for the RHC to review and consider adopting amendments to the Community Stabilization and Fair Rent Act Regulations, Chapter 13. A little bit of background on this. On January 31st of 2023, August 21st of 2023, and October 16th of 2023, the Rental Housing Committee conducted study sessions on the treatment of utility charges in the CSFRA and the impacts of using ratio utility billing systems. On December 18th, 2023, as you know, the RHC adopted Chapter 13 of the CSFRA regulations. Since the time of adoption, staff has gained a better sense of the implementation timeline and learned about additional topics that staff recommends addressing in the regulation. There are three proposed changes or updates to the regulations. Two are just administrative clarifications that do not require committee approval this evening. One is an administrative clarification to Section A1C. Two is the actual recommended change for Rental Housing Committee consideration this evening. This is the one that we would like your input on, and that is a change to Section Table 2. And 3 is an administrative clarification to Sections B, 18D, and Table 3. So the first, we are going to cover the administrative clarifications just so that you know what we're proposing and why. It was easier to make this into one presentation this evening instead of having the confusion of two separate memos on the same general topic. So the first administrative clarification that does not require committee input is the administrative clarification to Section A1C. So staff has received inquiries from landlords and tenants regarding situations where landlords midway during a tenancy removed utility charges that had previously been included in rent and without a corresponding rent decrease began charging tenants for those utilities. This is considered a reduction in housing services, resulting in an unlawful rent increase for which tenants are eligible to file petitions. Additionally, in such instances, the one-time utility adjustment petition process cannot be used to incorporate utilities into rent. So the proposed administrative clarification to really cover this item is a little bit lengthy, just so that people have enough information to really actually clarify what's happening with this ineligibility. So the clarifications, and I can read through this if you'd like, but I was not planning to. I'll just go over the highlights of it. State that the utility adjustment petition process does not apply to tenancies where these four conditions are met. One, the initial rental rate for the covered rental unit was inclusive of utility charges that were paid by the landlord. And on or after the start date of the CSFRA, December 23rd, 2016, the landlord ceased paying for one or more of these utility charges without a corresponding decrease in the tenant's rent. At the same time or subsequently thereafter, the landlord began using a ratio utility billing system or any other such similar system or methodology to allocate the utility charges to the tenant, and the landlord demanded and the tenant actually paid the utility charges allocated to the tenant based on RUBS. So the foregoing scenario constitutes a reduction in housing services and therefore an unlawful rent increase pursuant to CSFRA Section 1706A and Chapter 2 of the CSFRA Regulations, Section H and P. And in such cases, the landlord is required to, one, roll back the tenant's rent for the covered rental unit to the rent that was in effect immediately prior to the implementation of RUBS or any such similar system, and to refund the tenant all overpayments in rent. As authorized by subparagraph 18 of paragraph D of this Section A and CSFRA Section 17D, a tenant whose tenancy satisfies all of the criteria in 1 through 4 Roman numerals above, may file a petition for downward adjustment based on unlawful rent with the division at any time. We then have examples of what this might look like. And the reason for this recommendation is to clarify that landlords cannot apply the one-time utility adjustment to tenancies where utilities were included in the initial rental rate and were, after the effective date of the CSFRA, separated out from rent without a commensurate rent decrease to be allocated and charged via RUBS. And two, that such actions amount to unlawful rent increases under the CSFRA, and that landlords must address such issues to comply with the CSFRA, and tenants may file petitions for downward adjustment to address the issues. I'm going to go over the other administrative change first and then come back to the one where we are requesting the RHC's approval. So the second administrative change is to section B18D in Table 3. And the background on this is that landlords, tenants, and hearing officers requested clarification about whether unlawful rent petitions related to utilities under certain circumstances can still be filed during the one-time utility adjustment process. And this confusion highlights the need for further clarification and explained in the following section. So section B18D states that petitions, this section of the regulations are about what type of petitions can be filed regarding utilities during this time period. And we wanted to clarify that petitions regarding unlawful rent charges for utilities, notwithstanding the foregoing, paragraph B does not apply to either of the following. So this is basically stating that if you have a petition for downward adjustment of rent that is based on overpayment of utility charges where the tenancy meets the criteria that I just spoke of in subparagraphs Roman numeral 1 through 4 in section A of this chapter, or any petition for downward adjustment based on overpayment of utility charges where the tenancy commenced on or after March 1st, 2024, and the landlord has unlawfully demanded or retained payment of those charges through allocated to a tenant using RUBS. In either of those scenarios, a petition can still be filed with the division at any time and will be heard and decided in accordance with the section, chapter 5 of our regulations. So those are our two administrative clarifications. And also we have a change to table 3. It's basically just saying that this type of petition can be filed by tenants and accepted by staff. And then the reason for this recommendation is the addition of the language in section B18D clarifies that tenants who have been unlawfully charged rent under the specified conditions are still eligible to file unlawful rent petitions at any time. And this addition informs tenants and landlords and hearing officers of how to handle such situations during the one-time utility adjustment petition process. And I'm going to go back up here to our recommended change to section table 2. So this is the one that we are requesting RHC input from. Staff began receiving and processing petitions in late 2024, and we've developed since then a greater understanding of the timeframes associated with submitting petitions, including but not limited to the amount of time required to gather supporting documentation and the amount of support required for landlords to complete the petition submission process. Therefore, we recommend extending the submission timeline by 2 months, and in the meantime, we will perform additional outreach to ensure that the petitioners are able to meet the extended deadlines. So as stated, we're proposing that the timelines be updated, and there is a typo here. This should say 8 months, but we're extending it until April 30th for properties with 21 or more units. And for properties with 6 to 20 units, we are requesting that the date be moved to July 31st. For a total of 11 months since the release date of the petition forms. And then finally, for our smaller properties, they would have 14 months to file the petition, and the deadline would be extended until October 31st. And again, due to penalties associated with missing the submittal deadlines and the length of time required to submit a petition, staff is recommending the above revised dates for the submission of petitions by landlords. So I'm going to go down now to the fiscal impact. The recommended changes streamline the one-time utility adjustment petition process, which may have a positive impact on the Rental Housing Committee budget because it is increasing efficiency and reducing administrative costs over time. The recommendation is for the committee to review and adopt amendments to the Community Stabilization and Fair Rent Act Regulations, Chapter 13, utility charges, clarifying certain aspects of the one-time utility adjustment petition process and amending Table 2 with regard to the timeframes for compliance. And this concludes staff presentation on this topic, and I'm happy to take any questions.
Thank you so much. So, does anyone have questions? Like Vice Chair Ma?
For purposes of putting on the record, the table 3 on slide 62 should say section A1C, correct? Patricia, did you get that?
Oh, yes, I said correct. I'm sorry. Can you hear me?
We can now, yes. Okay. Correct. Yeah, she said correct. Yeah.
Okay. And separately, do we have a rough idea of what percentage of landlords in the greater than 20 units category have submitted their petition?
Let me pull up those numbers for you, Vice Chair. So as of approximately noon today, we've had 65.4% of the properties with 21 or more units either submit the petition to us for review or inform us that they actually have utilities already incorporated into rent and will not be filing a petition or have filed a shortened petition form for that circumstance. So we did receive quite a few this afternoon, so that number is definitely a little higher than 65.4%, but that's where we stand as of about noon today.
Okay, thank you.
All right, Member Balch.
Yeah, thank you. So regarding the administrative clarification on section A1C, so I understand that a landlord's action to basically swap or to add a RUBS charge without reducing the rent constitutes a illegal rent increase. So, and then per the CSFRA, that would be rolled back. So it makes sense. Okay. So then basically now at the lawful rent is established at that rollback level. Why would the one-time adjustment not be valid on that lawful rent rollback level? My understanding of the one-time adjustment is to account for the appropriate utility charges that are currently being done through RUBS, having some accounting for that in the rent as a one-time adjustment. So if we establish a lawful rent level at the rollback point, why would we then disallow the one-time adjustment on that lawful rent?
The rollback, the amount that you get back to the rollback amount in this instance was already inclusive of utilities. So that's what this is saying. So that rent that tenant was originally paying included utilities, and then the landlord took it out and then started charging an additional amount on top of that rent. So for example, the tenant was paying $1,000 including utilities, and then the landlord then added RUBS on top of that, took that out. So now they're paying $1,000 for their rent, and we'll just make up a number, $200 for their utilities. So now effectively they're paying $1,200 a month. They've received a $200 a month rent increase.
Okay, thank you. So in other words, the rollback to lawful rent goes back to that time pre-RUBS where the rent that included the utility charge.
Correct. Okay. So in the initial time period before the landlord took it out and put it into RUBS, the landlord was in compliance with the law, right? Okay. And then they got themselves out of compliance with the law.
Thank you for explaining that.
Member Cox.
Yeah, I just had a procedural comment. Do I wait on that now or make it now?
Is it a question for staff?
Okay, I'm going to wait, and then you can call on me for procedural comment.
I would be happy to. Vice Chair Ma.
Can staff provide an explanation of the recommendation for a 2-month extension as opposed to any other time frame?
The 1-month time period felt that it would be not quite adequate, and 2 months felt like it would be more appropriate than 3 months. So based on that, we averaged the kind of average between the 1 and the 3 and landed on 2.
Okay, that's fine.
Yeah.
All right, if there are no other questions for staff, we will move on to public comment. In-person comments will be called to speak first. Any member of the public wishing to provide virtual comment on this item, please click the raise hand button in Zoom or press *9 on your phone. Staff will display a countdown timer on the screen. All right, we will start with Steve. You have 3 minutes.
Good evening.
Welcome.
Can you hear me all right?
Yep.
I didn't know if it was appropriate to speak at the beginning of the meeting, since it was somewhat related to the one-time utility adjustment. So I chose to wait. But my question is, I have submitted my petitions. They've been in process. We've been going back and forth with staff. And I've been trying to get an update for over the last 2 weeks. And since most of the people on that email are in this meeting, I just would like somebody to respond to my email and give me a status. I can appreciate there are a lot of things going on. I can appreciate, you're adding language and whatnot. My property started RUBS well before CSFRA was implemented, so none of this today's amendment clarifications are pertinent to my petition. So just would like a status so I can move forward. That's all I have.
All right, thank you very much. Patricia?
I will be happy to follow up with Mr. Welter tomorrow.
Oh, your hand is raised.
Oh, it is. Sorry about that. Yeah, I'll be happy to follow up with him tomorrow.
Oh, excellent. All right, seeing no further comment, we will go into committee deliberations and feedbacks. We can start with Member Cox.
Oh, right. Yeah, I was the one who put in the question about why we're being asked to approve something that is being approved administratively. And, first, I'll preface my comment by saying that I don't think this is a huge deal, but I do want to answer back to what was said in the question in the staff report. The reason I'm asking this is, and again, I will say that there was a specific request from the committee that when administrative changes go in, we become informed of them. Okay, and so I'm very much in favor of that, and I do want to know what's going on. But the reason I asked the question is that I felt that when it comes for the time for us to be making a motion, we should be making a motion over things that we have jurisdiction on, not things that are administratively decided. And so, I get it that, that it saves time by putting these two together. The only thing I was thinking is that whether it would have been even easier that when the resolution is written up, it only covers the stuff that we're supposed to talk on. So that's my clarification of my question.
All right. Vice Chair?
I believe is a motion.
A motion is in order.
Okay. I'll make the motion to adopt amendments to the CSFRA Regulations Chapter 13, Utility Charges, clarifying certain aspects of the one-time utility adjustment petition process, and amending Table 2 with regard to the timelines for compliance, including, adding the 2 months per box.
Motion made by the Vice Chair, seconded by Member Cox.
And I guess I can speak on the motion?
Please.
Yes, I agree with staff that, we are a flexible body and staff does provide us feedback of how the process is going in reality. And if reality strikes, then we need to react to reality. And therefore, I believe that the 2 months extension is reasonable.
Member Cox?
Completely agree.
Same. Any further deliberation? Then I believe it's time to take a vote. All right, the motion to adopt amendments to CSFRA made by Vice Chair, seconded by Member Cox, has passed unanimously. Yay. We will now move to agenda item 6.2, CSFRA and MHRSO annual fee payment and registration requirements. Public comment will occur after the presentation item and committee questions. We invite you to submit a speaker card now if you know you would like to speak on this item during public comment. We will begin with a presentation from staff.
Thank you. I'll begin with the presentation, going over CSFRA and MHRSO annual fee payment and registration requirements. So the purpose of this presentation is for the committee to receive an update on the status of compliance with the annual fee payment and registration requirements for the CSFRA and MHRSO. And for a little bit of background, the Rental Housing Committee requested periodic updates related to compliance with the fee payment and registration requirement. Annually, a rental housing fee for CSFRA and MHRSO covered properties are charged to fund the adopted budget, and payments of annual fiscal year July through June fees and registration requirements are due by the end of January each year, so it's actually billed halfway through the fiscal year. And continuing on the background, the Rental Housing Committee passed these following registrations over the past few years. So in 2020 and 2021, CSFRA and MHRSO mandatory annual registration requirements. And then in 2022 was the compliance and enforcement mechanisms for both MHRSO and CSFRA. And then in 2023, just before we rolled out the implementation of merging our rental housing fee with our registration on the online database, we had some streamlining updates to those regulations. And since the adoption of those regulations, staff has implemented education and outreach efforts during each registration and fee payment cycle to support landlords in compliance with the requirements. So here's sort of a snapshot of the last few years where we do a lot of landlord-focused annual registration and fee requirement webinars, and actually in-person workshops as well. We do targeted outreach and mailings and emailings and informational letters. And you'll see we really kicked some of that up in 2024 when we were doing the merge because we were switching up the system and we wanted landlords to know that they can pay the fee through our portal instead of what they were doing previously. And we also do a lot of direct email follow-ups to landlords who are non-compliant, where it is a staff person directly emailing the property owner and the property management with information on how they can become in compliance based on their personal situation and what they're not in compliance with. So it is tailored directly to the issues that that property is having. So we have already completed 57 of those this year, and we will continue to do that. And we do notice a large uptick in compliance after we do these personalized targeted mailings. And we did continue to do courtesy compliance letters to landlords. We did that in 2024, and we're looking into that this coming year, as well as our first non-compliance letters to landlords. And you'll really notice the difference between 2023 and our non-compliance, and in 2024 when we started doing a lot of targeted outreach. And I think it also has to do with combining the registration fee and the registration and the fee payment onto one platform. So it's a lot more convenient for property owners to comply with both requirements. So I did want to also mention at this point, this year in 2025, we have about 87 properties that are out of compliance. So it's even down again from last year in 2024. And we do plan to do that first non-compliance letter and a second non-compliance letter to landlords and a copy to tenants this year as well. And here we'll look specifically first at CSFRA compliance. So after the adopted regulations requiring the payment and fees are due by January 31st of each year, payment and registration after this date is subject to late fees and penalties. And so we sort of measure compliance in two categories. We look at how many people have registered or paid by January 31st, the due date, but then we also look at the whole year. And so we have two separate charts here to show that. So the first chart, we're looking at compliance by the due date of January 31st. And I wanted to look at the year prior to when we rolled fee payment into registration, and then this current year as well. So we'll start in 2023, and it was at 68%. And then you'll see now we're at 83%. And I did actually pull the numbers for today in case you're interested where we are as of this afternoon. And we're actually at 89% compliance with fee payments already just by the end of February. So we have had quite a large jump in compliance with all of our outreach efforts and our systems that we have in place. And then similarly, we have the full overview of fee payments for all years going back to the first year in 2018. And they're all within the high 90s, plus or minus 1%. In 2022, I just did want to note that there were additional payments that weren't captured in the memo. That's actually at 96%, and I think it was 93 in the memo. So just to show that correction there. And then we'll look here at registration compliance. Again, we have large increase year over year. This year, as of January 31st, we were at 83%. As of today, we're at 88%. And we are continuing our outreach with our letters. We're gearing up for our compliance letters, going to be mailed out starting in March. And it has been shown that that increases compliance significantly. And you'll notice the year over year compliance registration, we are expecting to sort of surpass last year and be in the high 90s as well. And now we'll look specifically at mobile home compliance. So we have 6 parks that are covered by the MHRSO, and this year all 6 parks have registered and paid by the due date. And we'll sort of break this down in the same way, where we look at fee compliance by January 31st. You'll notice this year is 100%. And again, I attribute that to some of that direct communication with the property owners and the management at the parks to make sure that all parks could hit the due dates by January 31st. And not much change in fee payment collection. They do end up paying each year. So continue the good work there. And similarly with registration, we do have already 100% compliance this year, which is great. I think last year we were missing 2 parks by the due date, but everybody was in this year before the 31st. And again, they all have registered in all required years. So 100% across the board there. And then I did just want to include here the attachments that were part of the memo, which is just a sample letter of our compliance letters that go out. So the first letter goes just only to the landlords, and we mark and indicate which of the requirements the property is out of compliance with, and it also includes an action there where they know how to remedy that situation. If within 30 days that has not been remedied, a second letter goes out with a copy to the tenants, and the tenant letters are translated English, Spanish, Chinese, and Russian, so that everybody can understand the information that's coming to them. That, again, should be coming out in March. We should start gearing up to do that. So fiscal impact, there is none. And that concludes the presentation. Are there any questions?
Member Cox.
Yes. The first question isn't, why does Robert not turn his microphone on? Okay. Anyway, so is it possible to make comments now or just questions?
Just questions, because we will have a public comment period. Member Keating.
Are these letters at full-size print in our packet, or could they be sent? They're in the packet already?
Are they like stuffed and mailed in the packet? What are you asking?
I want to read the...
Oh, yes, they are. Yes,
They
they're
are.
attachments in your packet.
Okay.
Member Rosas.
So thank you very much for all the hard work that you guys have been doing. I want to put that in there. But I did have a question in regards to any feedback from the landlords. So in regards to the compliance, because I do see like high numbers. So have you gotten any feedback in regards to like the webinars that you guys do, phone calls, and if you do, is there any way you guys can let us know what the feedback is?
Yeah, we do get feedback. We actually interact a lot with the landlords between the months of December and February. And we help them through email, over the phone, and we have office hours about twice a week. So the feedback about staff's assistance and the ability to use the system is good feedback.
Vice Chair.
I mean, this has probably been asked previously, but I'll ask it now. So does staff have any plans to address those final stragglers of 2 to 3% that do not make the 100%?
Yes, we have been trying to get creative in how to contact those property owners. So we've been working with other departments in the city who bill for other things such as utilities, and been trying to get contact information from other sources. And it has been successful in some ways, so we'll continue to try to get creative and contact people.
Okay, so that means there's like situations where they do pay their utility bills, but just choose for whatever reason not to pay the annual fee.
Right, and if the utility file has a different contact information than we have, then we will bill to the address they have on file. So that has been successful in some cases.
Thank you.
And then of course, we're hoping that the second compliance letter that actually goes to the tenants also provides some information about the property owners.
All right. Seeing no more questions, we can move on to public comment.
Yes, it is a question.
Member Rosas.
I'm sorry, it's just popped up. The question that I had was in regards to the, oh, yes, I'm sorry. Remind me, because I know it's been a while. So the letters the letters that are sent to the renter, they get sent because the landlord has not been compliant?
So there's a first letter that goes out, and that goes out only to the property owner. Mm-hmm. And if the property owner is still not in compliance after, at least 30 days, sometimes it could be a little more than 30 days, then it triggers a second letter that goes out to the landlord with the tenants copied on that.
Oh, okay, thank you.
And instructions for the tenants to get in contact with our office.
Okay, thank you.
Okay, now we can go to public comment. Any member of the public wishing to provide virtual comment on this item, please click the raise hand button on Zoom or press star 9 on your phone. Staff will display a countdown timer on the screen. Seeing no comments, we can now move on to committee comments. Member Cox.
Yes, okay. So it's an issue that we've raised before, but I'll mention it again. And I also understand that, I'm not asking for immediate action on this because we know that RUBS is important and we want to get past that. And that should be the major focus of what the rent stabilization division is dealing with right now. But the stragglers still bother me. And so, and let me say this, again, there's some kind of things that could bother me more than others. I mean, if we're talking about like new properties that are coming onto the market or a new landlord who just, is, he's not familiar with things and then, he gets corrected and he fixes it, that's less of a problem than if we have a recalcitrant landlord who is just, he's always in that 5% every year. And that's what I want to know about because I think, I've seen testimony come from people that, that they believe that rent control is just morally wrong, and so they're just not going to, get in line with it. And, I don't think that's valid. Everybody has to follow the law. So, there's several ways we can do this. Like next time you come up with a report, if you have some insight into that, you could put it into the report just so that we know, okay? Or, maybe we can take it as a study session when staff has time. But I'm just stating now that's my main concern. Thank you.
Thank you. Member Keating?
So I'm looking at the landlord sample letter, and so certainly the rental housing staff knows if the registration is incomplete or if the housing fees are not paid. But then there are other boxes here. Multiple increases, rent rollback not implemented. Do you ever use those, and what triggers you having that information to use the other boxes?
The majority of the time we are focusing on registration and fee compliance, but there have been a few instances where we use the other boxes. For example, we became aware of some housing services that were being taken away through another process in the city. So we did reach out to the landlord regarding that, and a letter was sent because of that.
Thank you.
But it is a small handful of people.
All right, any more comments or deliberation, feedback? Thank you. All right, we will now move on to committee staff announcements and updates. So,
thank you. Item 7.1. Okay, we'll look quickly at upcoming workshops and help center dates. And we do continue to have our weekly office hours that are virtual only. That's every Tuesday between 10 a.m. and noon. They continue to be well attended, so they are very useful for the public. And we do also have some upcoming workshops. On the 11th, we have our last property owner registration and annual fee workshop. This one is going to be in person and hybrid, in person and over Zoom. It's going to be held at the community center at 2 p.m. And the 13th, we have a submitting a utility petitions landlord virtual workshop. And on the 13th as well, in the evening, we have a tenant-focused hybrid workshop at the community center and on Zoom, and that's going to be looking at hard conversations and talking about mediation between landlords and tenants. We are continuing to have our landlord housing help center every single Thursday. Attendance has not dropped, so we are going to continue to do the every Thursday as that's needed. And those are in person as well as online. We do have a lot of people, I think, mainly coming in right now regarding registration, fee payments, and the utility petition. And our Housing Help Center for tenants continues to be twice a month, the first and third Thursdays. Those are also very heavily attended, and people are accessing most of the different organizations and services. So they come in for a number of things, and they talk to our staff. CLESPA is there for legal services, and CSA is also there, mainly helping people with rental assistance, but also providing a list of all the other services that they provide there. So that has been very helpful to the public as well. So that is the end of the presentation. Any questions about outreach?
Vice Chair?
A minor question. Is it possible to get a shorter link to the housing help clinics? It seems a little bit long to type the entire name in full. Like, is it possible just like mountainview.gov/HHC or something?
We can look into it. It's ultimately the choice of another department, but we will look into that.
Anything you like? Member Rosas?
So I'm just curious. I haven't heard any comments yet, but since we are going through this new process of the new administration, have we had any issues with immigration?
We haven't had any issues with immigration as far as them coming to our workplace or interfering with the work that we are doing. We do have information for the community because the stress is high currently, and we are aware of that. And we have also been brainstorming about how best we can communicate and still continue our outreach to the community and where they might feel the most safe. So whether that's online instead of in person, we're sort of gathering that information and adjusting as needed.
Thank you.
Any more questions? Then we can move on to the future agenda items for RHC meetings. So a month from now, on March 27th, we will have a study session on tenant anti-harassment and retaliation protections. Yeah, fitting, right? Any additional comments or announcements from the committee members or city staff? Member Cox.
Yeah, I just have a question. I had put this into the questions, but I didn't see it answered in here, so I'm going to ask it right now. During the council meeting where they discussed, the parameters for the AGA for the mobile home parks, there were a number of comments made. Like one landlord had commented that he thought that the petition process was complicated, and there was a question about whether it could be simplified. And a second one was about, the idea that the charges for fees for the mobile home park administration is higher than other mobile home park rental charges in other places in the Bay Area. And so my question back is, and it's perfectly okay to say that, nothing's been done on this yet, but I just wanted to know, because I have gotten questions about, well, what is the RHC going to do about that next? So is there anything to say yet?
Absolutely. So indeed, the City Council in their deliberations requested to look into a simplification or streamlining of the petition process, and we will definitely bring that up to you guys, the Rental Housing Committee, in our next year's work plan to see where that fits in. And then with regards to the fees, the City Council requested that the general fund of the city would contribute to the MHRSO budget so that the fees could be lowered. So we're working on that as well.
Thank you.
Any more comments, updates? If not, move on to the last item, adjournment. The meeting is adjourned at 9:37 p.m. The next Rental Housing Committee meeting is scheduled to be held on Thursday, March 27th at 7 p.m. Good night, everybody.